lords and my lady, the main generic issue in this appeal, as the court well knows, is whether foreign national prisoners convicted of serious crimes and subject to deportation orders made by the Secretary of State in the public interest should be able to claim damages for false imprisonment, because the orders which the Secretary of State had power to make were flawed, because the policy pursuant to which they were deported was one which did not admit of exceptions, first, and because the policy was unpublished and inconsistent with published policy, second. My lords, my lady, the unease which the appellant's claims may generate is not simply, in our respectful submission, a function of a hostility to the view which was reflected in paragraphs 150 and 151 of the judgment of Mr. Justice Davis, that persons who have so signally abused the hospitality of their host country should receive compensation from public funds for a detention which could have been implemented in their cases on any view in full accordance with the law, not least because Mr. Hussein's submission is right. There is a large cohort behind these leased cases who are similarly situated. Mr. Justice Davis rightly, of course, if regretfully, rejected such approach. As my Lord Hope reminded us in the Abu Qatada case, everyone, however unmeritorious, is entitled to the protection of the law, although it is sometimes not entirely easy to identify what the law is whose protection they seek. The unease in our submission is rather that in this area there appears to be a lack of synchronization between private and public law. This is not a case, I repeat, in which the Secretary of State did not have statutory authority both for the proposed deportation and the consequent detention. The flaws which are identified by the appellants are properly characterized as public law flaws. The classic case of false imprisonment is where a detainee, whether be a private person or a public authority, lacks power to detain the detainee at all. A challenge on that ground is not available to these appellants, nor, of course, axiomatically, are they able to claim damages merely for breaches of public law in themselves. The grant of any public law relief is inherently discretionary, and yet the appellants have claimed...
Well, that doesn't apply to habeas corpus.
No, not to habeas corpus. I wouldn't describe that as being a classic public law relief, but, my lady, it's more...
I would have thought it was the classic
I was going to say it was more important than that. My lord, my lady, the basis upon which they found their claim and these appeals remains the dictum of Lord Diplock in the case of Holgate and Duke Mohammed, which they rightly claim and describe in their printed case at paragraph 57 as the leading case. It was there that for the first time in our submission, the proposition was articulated that damages could be awarded not only in circumstances where the detainee had no power, but where he had such power, but had, in accordance with Wednesbury criteria, misused it. And my lords, my lady, it is an act of some temerity to submit to any court that Lord Diplock may have erred. But whatever he meant, and I shall return to his speech at a later stage, he might have, we would submit, have expressed himself somewhat more guardedly had he been gifted with prophetic powers and appreciated the full implications of his dictum against the efflorescence of public law principles over the last 3 decades, violation of any one of which, if the appellant's arguments be sound, would equally nullify a power of detention and create a right to compensation. My lord, my lady, before I develop more fully the issues which engaged the court under the first generic issues, I wish to make some introductory remarks which will frame much of what I, with the assistance of Mr. Tam, will submit later. First, let me make it clear that the episode in which the appellant's cases are located was not the Home Department's finest hour, an observation which may itself contain a degree and a conspicuous degree of meiosis. It was not its finest hour, either in terms of the way in which the new approach to the detention of foreign national prisoners, former prisoners, in April 2006 was implemented, or indeed in respect of a somewhat spasmodic revelation of that policy to claimants and, no less importantly, the courts. Both were errors and examples of errors of administration, which certainly in the former instance involved breaches of public law, and in the latter fell short of the standards that the judiciary have come properly to expect. So my starting point on behalf of my clients is an acceptance of the criticisms which were trenchantly made below, both by Mr. Justice Davis and by the Court of Appeal, with which this court by now will be well familiar, since they were properly and predictably cited by Mr. Hussain. I must, however, submit that at both levels, the courts were right to find that there was no evidence of bad faith. A few individuals may, in emails, which no doubt with the benefit of hindsight they regret having sent, betrayed a somewhat casual attitude even to the rule of law. But those isolated incidents cannot provide a basis for asserting a deliberate design on behalf of the department to conceal the change of policy from, or indeed to mislead affected parties as to what the true policy was. Indeed, from April 2006 through to November 2007, the date of Cullen 1, as it's mysteriously called, it may be dignifying the state of affairs which existed as a policy at all, an observation that the Court of Appeal made at paragraph 34. These matters as points of fact will be dealt with at a later stage by my learned friend Mr. Tam, but I make two prefatory observations. First of all, it would be an extraordinary start to a policy of concealment of a policy when the Secretary of State himself, the author of the policy, was public both in his statements to the House and in interviews freely given to the media about what the policy was. And secondly, in our respectful submission, one must differentiate between concerns about the possible legality or lack of legality of a course of action and equating that to a decision to defy the law. It is often the case, as my lords and my lady will know, that persons, counsel come before you to defend the decisions of public authorities which have raised controversial issues as to their legality. Sometimes the cases are won, and on other occasions they are lost. But in our respectful submission, until a court has authoritatively pronounced upon the rightness or wrongness of a particular course of action or a policy, there is no question that until that time, fidelity to the law is being ignored. After that time, certainly. But in our respectful submission, that point was never reached in the circumstances of this case. And we say, despite Mr. Westgate's able submission and the continued search on the appellant's lawyer's part for yet further documentation between the Court of Appeal hearing and the hearing before this court, designed, of course, to unearth any smoking gun, none was ever found, and in our submission, none ever existed. And the fact that disclosure has continued without attempts to conceal, even as the Court of Appeal noted, embarrassing records, gives the lie to a suggestion that this department did not wish this court to have as full and fair a picture as is available. There must, in the light of the overriding objective, be a limit to what needs to be produced for this purpose, and those instructed me have tried as best they can to respond positively and conscientiously to requests that we concede are proper. But what has been produced in our submission is, in effect, no more than what was produced before. It was, in the phrase already deployed before the court, more of the same. So that's the first introductory submission. The second is that it is no part of the department's case that the common law value of liberty, a value which preceded the advent of democracy itself, should be, or indeed has been, in any way ignored. Just as the right to be free from restraint is the starting point, the law has always recognised, and does recognise, that there are limits on that right in appropriate circumstances. And the detention of what I call designated deportees is a recognised limit and vouched for in the United Kingdom by legislative fiat. Thirdly, and I seek not to resurrect any point of pure populism, the appellants in these league cases share the status of others to whom the published policies or practices which predated them but to the same effect in having three salient characteristics, all of which are germane to the issues that are debated before the court. The first is not, of course, that they were aliens, because aliens are entitled, as has been rightly said, to the same guaranteed rights as others. The first point is that they were designated deportees, and for present purposes, in particular in the light of unsuccessful challenges to date, must be assumed properly to be so. Secondly, they had that status because the Secretary of State for the Home Department deemed their continued presence in the United Kingdom to be contrary to the public good. And the third was that the reason for his conclusion in respect of these two appellants is that they had been guilty of very serious crimes, including crimes of violence, and in WL's case, I'll continue to use, if I may, the initials, sex crimes as well. It's appropriate at this stage to respond to the entirely legitimate concern that my Lady Baroness Hale raised about the position of the wife and child. And there are 3 points that I wish to make. Firstly, it is clear that at some stage an intimation was given that a notice of intended deportation was to be served on both those persons. We've been unable to ascertain that that was in fact ever implemented, and the fact that there was no appeal against that, which in the case of a child would have succeeded within a matter of seconds, if not minutes, tends to suggest that decision or that intimation was not in fact implemented. Secondly,
Does nobody know the answer to that question?
No one knows. We have been exploring as best we can. But when I tell you, as it were, the denouement, you may be, I hope, satisfied. I mean, the second point is, of course, we concede that it would not be proper to seek to deport a person who was a British national. There is an explanation for why it is that in this particular case, the child was even, as it were, had an intimation that action might be taken at some future date on another basis, and that is that he acquired British nationality, not of course as a matter of birth, but as a matter of registration at a particular time. And it may be that those in the department who were concerned with immigration issues were not, as it were, aware of what had happened in that part of the department dealing with nationality issues. In other words, that these letters were sent on a historic but not a current basis. An error, but a forgivable error. And the third is, and I hope my lady is consoled by this, there is no intention now to seek to deport either wife or child. There may be, of course, legal consequences that follow from that, but they are not those that presently engage the court. Now, the fourth introductory remark I make is that insofar as it is admitted, and of course it is, that there were public law flaws in the approach to the cases of the appellants, it is not the department's case that the court is powerless to express its conclusions by appropriate relief by way of the remedies of judicial review. The issue is not whether public law illegality can be overlooked, it cannot. But whether additionally these appellants should enjoy the private law remedy of damages for false imprisonment. And fifthly and lastly, it is a feature of this case, as has already been noted in questions put to my learned friend, that the European Convention on Human Rights, which is usually regarded as a lodestar in the area where human rights are concerned, is sympathetic, its jurisprudence, to the department's case in two ways. The first, in the fact that it does not require, it appears, any justification for the detention of persons in the appellant's position, other than they should be designated, according to the law of the member state, as deportees. And secondly, and associated with the first, it does not require, it appears, compensation for any detention which is validated on the basis of its being effected with a view for deportation. And it's also interesting to note that in this general area, if and so far as damage is to be claimed for a violation of rights under Article 5, a proof of damage is required. I shall show your lordships and my lady the jurisprudence at a later stage. And just finally, my lord the President asked me the basis upon which certain of the documents that have been produced were redacted. And the answer, in short, is this. Firstly, public interest immunity was never sought or claimed. Secondly, from time to time, legal professional privilege was claimed, though equally it was waived in the interest of providing to the court a coherent picture of the development of these policies. And thirdly, the acid test that was applied was the test of relevance. And obviously, in circumstances in particular where there were repeated requests from the appellants and their lawyers, particular care was given, generally, as it were, to err on the side of disclosing that which might be thought to be relevant. But in documents of the kind that I think my Lord the President had in mind, a letter that went up to the Prime Minister, I think at that stage, Mr. Blair, particular care was taken to disclose only that was relevant, and not, as it were, to be casual and say, as it were, let it all go. So those are the position on instructions that I've taken. My Lord, it may be helpful, not least because of the efflux of time, if I were to hand to the court, if it's convenient, a document which sets out in form the propositions that I intend to advance under the various headings which are in issue. Has this been pointed out already? Right.
Mr. Beloff, we've been shown a document which is headed Key Submissions, Appellant's Key Submissions. I take it these come from Mr. Hussain and...
I'm not familiar with...
Have you not been shown these? Well, have they been shown to Mr. Beloff?
I've seen it with I think that's the one with the headlines, which was blacked out. I haven't seen it.
I see. Yes, I'm sorry, yes. So the only new bit is the headings, is that right? Right, thank you.
I make no complaint. I haven't actually seen the second or third edition. I've got a copy here.
Very brisk.
And since we are in a public court, will I be forgiven if I may just briefly for reading these propositions before developing them? If there's a sense of a forensic sat-nav.
Mr. Bell, I wanted to put on the other microphone. I'm not sure it'll make a lot of difference, but it just might. That one, that's it now, that's it, you've got it. Oh, there's another one in the middle.
One underneath.
There's one underneath. I'm now on all sides. I'm detained by microphones. I'll do my best to take advantage of the technicalities as well as my own voice insofar as it survives the term so far. So I'll deal, as your Lordship, my lady, will see flicking very rapidly through, we deal both with the generic matters and with the particular case of WL. It would be undue optimism on my part to believe that we're going to reach the WL matters this afternoon. So if I may, I will just simply read those that refer, the 12 propositions that refer to the generic cases. Some will indicate common ground, and some, you will see, indicate the battleground, but it's important in our respectful submission to distinguish between the two. Insofar as Schedule 2 of 1 to 3 of the Immigration Act of the Immigration Act 1971 as amended, that's not in fact a perfect reference, gives power to the Secretary of State to detain those immigrants in respect of whom statutory conditions precedent for detention are satisfied, the Secretary of State is entitled to have a policy for detention as long as it is not inconsistent with, firstly, any overriding European Union law, secondly, a detainee's convention rights, thirdly, statutory duties, for example, under anti-discrimination legislation, fourthly, Hardyall-Singh principles, and additionally, it satisfies Wensbury criteria of rationality. Secondly, such a policy may permissibly provide for a presumption of detention for such prospective deportees who have been found guilty of serious crimes and who constitute a risk to the public if not detained, who I call serious offenders. Thirdly, such a policy must not either be a blanket policy admitting of no possibility of exceptions and or, if I can use the phrase, if unpublished, adversely contradict any published policy which is a source of legitimate expectation for those to whom it is applied and or a relevant consideration for those by whom it is applied, using the vocabulary of public law. Such a policy, fourth, should itself be published if it will inform discretionary decisions in respect of which the potential object of those decisions has a right to make representations. Fifthly, the unpublished policy, providing between November 2007 and September 2008 for the detention of serious offenders without possibility of exception, as distinct from the concurrent published policy, which provided for a presumption of release subject to exceptions, as well as any practice between April 2006 and November 2007 inconsistent with the published policy, violated the principles that I set out in paragraph 3. Sixthly, it is accepted that a detainee would be entitled to challenge the varies of the unpublished policy by way of an application for judicial review, and subject to satisfying the procedural preconditions for such application and to the court's discretion, obtain appropriate declaratory or quashing relief in relation to that policy, but non sequitur that he'll be able to obtain damages for false imprisonment as well. 7. The tort of false imprisonment has two ingredients: the fact of imprisonment and the absence of lawful authority to justify it. The onus lies on the detainor to establish justification. That onus is satisfied if the detainor can establish that a statutory power to detain the detainee was exercised in relation to him. The onus then shifts the detainee to establish that the authority to detain should be treated as vitiated because of some wrongfulness in the exercise of the statutory power. Eighthly, if the detainor has no power to detain, the detainee can obtain damages for false imprisonment. Ninthly, if, however, the detainee's challenge is as to the exercise, not the existence of the power, the detainee must establish a causal link between the alleged misexercise and his own detention. Tenthly, alternatively, damages for false imprisonment should only be available in addition to where the detainor has no power to detain, where the exercise is vitiated by bad faith or improper purpose. 11th, the Department, the Secretary of State, had authority under statute to detain both WL and KM and did not exercise it in bad faith or for an improper purpose. Each would have been detained under the published policy and hence are not entitled to damages. And 12th, there is no basis on established principles of law for an award of exemplary damages against the department arising out of either the unlawful in public law terms operation of the published policy or practice described in paragraph 5 above, or in the way in which it performed its disclosure functions in this or other associated legislation.
Litigation.
Litigation. Your Lordship is quite right. Yes. May I then take those propositions, as it were, one by one? The first proposition identifies what is the major battleground between the appellants and interveners on the one hand and the department on the other, insofar as they would say that it inadequately describes the reach or extent of the power of detention. There is, of course, no issue between the parties with the proposal that it is proper, indeed it's submitted by Mr. Fordham and Mr. Hussain and Mr. Singh, for the Secretary of State to have a policy. Policy making, of course, is a lawful and indeed desirable function of public administration. And so as to the proposition that we've advanced, we assume that there is no issue with the positive assertions of the limitations that we accept in subparagraphs 1 to 4 in relation to the validity of a detention policy or not.
Is there an issue about the word entitled in the beginning of the fourth line? Can I explain? I mean, I'm thinking of Gillen, for example. I mean, does the proposition against you go to the length of saying that the Secretary of State was required to have a policy, given the nature of what is being undertaken under the statute? I understood the argument to be that in order to avoid arbitrary use of the statutory power, it was necessary. So it's not just a matter of entitlement, but a matter of requirement.
It's a matter of, well, in a sense, our proposition 4 deals with that because it's the obligation to publish in circumstances where a discretionary decision could adversely affect someone, and therefore, to that extent, and your Lordship's point is about the degree of precision that is required in respect of policy, which is a matter I'll come to in relation to Gillen itself.
Well, it struck me, I'm bound to say, that when you look along to number 11, for example, and the way you approach the propositions at the end,
yes,
where you rely heavily on the statute,
yes,
that may not be the entire picture. And if the position is, and I don't know yet whether you accept it, that you were required to have a policy that wasn't a matter of choice but a matter of requirement, then one may look, I suggest, beyond the terms of the statute to the policy itself in deciding whether or not your answer under the later points can stand up to scrutiny.
Well, it's clear that the exercise of a discretionary power of this kind cannot, we would submit, either under the convention or common law, be arbitrary. So to that extent, there must be some degree of precision as to the kind of criteria that are engaged. The contest may be, as it were, how deep down does one need to drill?
Yes, I see.
I mean, you could insert into the fourth line after the word entitled, and the respondents would, and the appellants would say, is bound.
Well, that's what they would certainly say, yes.
So would you accept that? The Secretary of State is bound to have a policy.
Well, I think in this area there must be some policy, and indeed there always has been. At any rate, certainly in recent times. I mean, we're sometimes recollect the early days of immigration appeals and the like, and there were, even in those days, my recollection serves me right, rules that formed the subject matter of debates as to their proper construction and application.
Well, I'm not sure if at Hardyal Singh time there were actually any published policy at all. I don't.
In relation to the detention issue.
In relation to this class of detainee.
Yes. Well, there certainly is now.
Oh, of course.
Yes.
And has been, we're told, since at least 1991.
Yes. Well, that reflects modern understanding. I mean, I'm scarcely, if it were put it like this, there's no purpose in my debating an academic issue when the department accepts in general terms that there needs to have a policy. Obviously, the policy has to be a rational one in the sense given to that epithet in public law. So the real issue in relation to Proposition 1, as we understand it, is whether our recognition of the limits on the power to have a policy of detention is sufficiently expansive. And those who are in the opposing forensic camp say that the right of liberty is so potent, even indeed paramount, that no discretion, unless it is expressly vouched for by unimpeachable legislation, can be exercised so as to be subordinate to a policy that has, even allowing for exceptions, a presumption in favour of detention. The Court of Appeal, as the Court well knows, concluded that a policy containing a presumption of detention would not be unlawful for that reason alone. See paragraphs 48(2) and 59 through to 69, which have been well read already, and we seek to uphold their conclusion in our printed case between paragraphs 5.1 and 5.59. In our respectful submission, the division between the parties on this issue is caused by their different perceptions of what is meant in legal terms about the various judicial and other pronouncements on the importance of the right to liberty. Our starting point is that as a matter of legal analysis, that importance is recognised by the rebuttable presumption that any deprivation of liberty is unlawful. It being a rebuttable presumption, it is accordingly a presumption that is capable of being rebutted. And we accept that that is reflected in the tort of false imprisonment, and it's reflected in the priority given to habeas corpus applications and indeed the elements of habeas corpus itself. But our submission with the more, as it were, nuanced approach, we say, is properly founded in the classic dissenting speech of Lord Atkin in Liversidge and Anderson. And can I just remind your lordships, as my lady, as you well know, that what has, as it were, echoed down the corridors of history since that decision was a reflection that Lord Atkin was correct in what was then a minority and indeed much criticised view that when a statutory power was given to detain on the basis that the Secretary of State had reasonable cause to believe something about someone, that should give the Secretary of State free power to simply say, this is what I believe, and that the court was not entitled to interfere with or indeed reconsider his assessment of reasonableness. What was not in issue between the parties, because that debate has nothing to do with the issue before the court at the moment. What was not in issue between the parties was the way in which the value of liberty was to be recognised in the common law and infuse the relevant statutory power. So can we go, if we may, to Liversidge and Anderson and look both at the minority and at the majority judgments, which in our submission were at one on this particular issue. And we start, if we may, with the passage that we cite at paragraph 5.26 of our printed case at page 245.
Which bundle are we looking at?
We are looking, my lord, my lady, at Authorities Volume 4 at tab 40. It's at the top. I'm going with any assistance. I hope as much as possible, given the very full citation of authority for certain propositions in our printed case, and bearing in mind the limits of time and the difficulties in simply extracting authorities from the bundles to refer to the printed case and the extracts, that this is so critical in our respectful submission, and in any event we need to refer to the majority judgments, and I fear I had to trouble your lordships and my lady with looking at this. It's at the top of page 245 that one finds, of course, the forceful, some might say uncharacteristic language Lord Atkin used about the reasoning process of the majority in terms of statutory construction. I repeat, that can be put in the margins, irrelevant to this particular appeal. What is highly relevant is the way in which, against that background, Lord Atkin then analysed why it was that Mr. Liversidge or Mr. Perlsweig was entitled to know why it was he was being detained. And this, the relevant passage starts 6 lines from the foot of the page. The appellant's right to particulars, however, it's odd that so important a case turned on pleading issues, is based on a much broader ground. And here we are, the ground upon which Mr. Hussain plants his flag. A principle which is one of the pillars of liberty, in that in English law every imprisonment is prima facie unlawful, and that it is for a person directing imprisonment to justify his act, and then he makes an exception in respect of judicial orders. So there it is, recognising in the appropriately florid language the reference to the pillar of liberty in English law, and then describing it in the way in which we respectfully submit it should be described, namely that one has a prima facie every imprisonment is lawful, and it's for a person directing imprisonment to justify his act. And one sees that in this particular respect there was no debate between either the majority or the minority. If your lordships and my lady would be good enough to go further forward to page 257, one sees equally the respect paid by Lord Macmillan to the value of liberty. And what he says is 2/3 of the way down the page, after the citation, perhaps I should take the second main paragraph on that page. My lords, I make no apology for having discussed so fully the various aspects of the question before the House, for it is one of the highest importance. I yield to no one in my recognition of the value of the jealous scrutiny which our courts have always rightly exercised in considering any invasion of the liberty of the subject. Then he goes on to refer to Halliday and the fact that sometimes it has to be sacrificed. The liberty which we so justly extol is itself the gift of the law, and as Magna Carta recognises, may by the law be forfeited or abridged. So when one goes back, as from time to time one does, and Mr. Hussain did so in his printed case, one looks back to Magna Carta and one recognises, one starts with the liberty, and one has it balanced by the fact that under law, and by law alone, may it be forfeited or abridged. And again, then, he goes on to deal with why that condition is satisfied, and putting on one side the issue as to whether the court could interfere with the judgment of rationality of the Secretary of State's decision. At 258, he says, 3 lines in my opinion, the production by the Secretary of State of an order of detention by him ex facie regular and duly authenticated, such as the House has before it in this case, constitutes a peremptory defence to any action for false imprisonment and places on the plaintiff the burden of establishing that the order is unwarranted, defective, or otherwise invalid. And that, again, in our respectful submission, has importance when one comes again to consider the shifting burdens in this particular area. And at 260, Lord Wright again, and again I cite this passage in particular because all their lordships were at one in recognising the historic pedigree of the right to liberty, and one sees, casting one's eye down the page, reference to the famous constitutional charters, the Petition of Right, the Bill of Rights, the Act of Settlement, did involve the liberty of the subject, etc., etc. Then Lord Wright, having, as it were, made the entirely appropriate genuflections towards the historic recognition of the right to liberty, he then comments some 8 lines from the foot, 10 lines from the foot of the page. All the courts today, and not least this House, are as jealous as they have ever been in upholding the liberty of the subject, but that liberty is a liberty confined and controlled by law, whether common law or statute. It is, in Burke's words, a regulated freedom. It is not an abstract or absolute freedom. Parliament is supreme. It can enact extraordinary powers of interfering with personal liberty, etc., etc. So again, entirely conscious of the importance of the value, they recognise, the House unanimously, that it's not an absolute value. The real issue is, given that anyone who is detained is entitled to know why he's being detained and entitled to have justification for that detention, it is, as it were, a rebuttable presumption. And there are frequent subsequent analyses and adoptions of that philosophy. For example, my learned friend Mr. Hussein referred to the Kawaja case some 20, 30 years later, volume 6, tab 59 at page 110, one sees Lord Scarman, again, no enemy to liberty, at page 110, repeating precisely the same sentiment. So in our issue, the submission, the real issue is therefore whether in any particular circumstance the déteneur can point to a clear basis in law for the detention. And in our respectful submission, in broad terms, the respect for liberty is satisfied, and the presumption that otherwise exists in its favour is rebutted by the statutory provisions in Schedule 3, paragraph 2 of the Immigration Act of 1971. So can I ask you again to look, if you would, in the first volume of authorities at tab 1 to those provisions. And we've sought to analyse them, I hope not uncontroversially, in paragraph 5.10 of our printed case. Yes, here we are. And as we say, those powers reflect, and now quoting from paragraph 5.10 at page 17 of our printed case, there are 3 detention powers which may, depending on the facts of the case, be exercised by the Secretary of State in relation to a person who's facing deportation proceedings. These powers reflect the different routes by which an individual who's liable to deportation may become subject to deportation action and statutory recognition of the making of a deportation order. And then we identify the 3 separate grounds with which the court is by now well familiar. Now, your Lordship and my Lady know that there was an issue raised at first instance and debated by Mr. Justice Moses, as he then was, in the Sedrati case, and Mr. Justice Calvert-Smith in the Volk case, as to whether or not, and if so, to what extent, there was a presumption of detention in the statutory language itself. We've dealt with that, and respectfully suggesting that Mr. Justice Moses' declaration made by concession, if literally taken, is a misconstruction of the statute. We've dealt with that at paragraphs 5.11 to 13, and more lavishly at 5.33 to 5.51 of our printed case. We do not, of course, resile from what we've there set out, but it may not be the most fruitful use of my lord's and my lady's time to travel in detail over that terrain. As my lord the President said at one stage in Mr. Hussein's argument, there's limited assistance that can be gained from the judgments of courts of first instance when one is at the highest appellate court. And since this all depends upon the construction of the language of the statute, I would prefer, unless your lordships and my lady direct otherwise, simply to concentrate on the language of the paragraph and its implications and leave our written submission on the so-called Sidrati debate to speak for itself. And in respect of those paragraphs, we make the following submissions. Firstly, it is clear, and indeed it is not disputed, that the paragraphs themselves involve no constraint on the power of the Secretary of State, granted to him by Parliament, to have a policy in favour of presumption of detention. They do not purport to fetter the discretion with which he is endowed, either to detain or to release, as the case may be under the relevant paragraphs. Secondly, in our submission, the tilt, if I can use that word, or the steer, at any rate, of paragraph 2.1 and part of 2.3, 2 bracket 3 close bracket, appears to be in favour of detention, in the sense that one starts from a position where in 2.1 there is a detention existing, and what the statute does is to provide for the possibility of release. So in other words, what the legislature has contemplated is it's for the Secretary of State to rationally consider whether there should be release rather than to justify a detention. And the third submission we make is that insofar as Justice and my learned friend Mr. Rabinder Singh seek to engage at this juncture the well-known principle of legality, it's clear in our submission that Parliament has not here overlooked the implications of conferring a power of detention on the Secretary of State. The whole of these 3 paragraphs of this particular schedule constitute in the round a carefully structured provision differentiating between different situations. Situation 1, where the detention should continue by reason of the satisfaction of conditions laid down in the statute itself. See the introductory words of 2.1 and indeed of 2.3. Secondly, where the Secretary of State has a discretion to detain. See in particular paragraph 2.2 and 2.3. It's the proviso to 2.3, forgive me, which was the one that, as it were, was a statutory vouching actually of detention. And thirdly, of course, where the Secretary of State has a discretion to release, see in particular paragraph 2.1. So it is in our respectful submission fanciful to say that the legislature has somehow ignored the right to liberty. On the contrary, they have addressed it and they have provided for the rebuttal of the presumption which the law makes in its favour. Now, the reason I use the phrase, has the legislature be taken to have overlooked the significance of the powers that they are conferring, so I have in mind Lord Hoffman's analysis in the Sims case in relation to what is the purpose and underlying the principle of legality. Could one just look very briefly at what Lord Hoffman there said in the Sims case?
Is this taking the political cost point?
It's not just the political cost, it's the other point, the generality of has the legislature, in the generality of its words, overlooked something that was germane to the power that they've conferred. I hope that's Sims. Yes. No, Sims. Forgive me. The prisoner's correspondence case.
10.107.
10.107, yes.
Is anything to be concluded from the fact that these powers are in a schedule?
No. They are as much a part of the legislation as anything else.
Except that it's not possible to amend a schedule. So the fine distinctions that are there in the language of these paragraphs may have been carefully worked out by Parliamentary Council, but they're unlikely to have been carefully worked out by Parliament.
No,
Well,
I think
I
schedules are open to scrutiny.
Well,
You have then, do you not to move against the whole schedule?
Well, I mean, in one sense, if my lady is right, and I'm assuming that my lady is right.
I may not be right, of course I may not.
Assuming that my lady is right.
I have been asked myself in the past, that's why I'm asking you the question. Why did you put it in a schedule?
Yes, it's the presumption of correctness of anything my lady says to me that I'm operating on. On that assumption, the fact that it's, as it were, writ in stone rather than being malleable, in our respect for submission, gives more force to it. Secondly, because on any view, it is part of the legislation. And thirdly, insofar as my lady says Parliament may, I've overlooked or not, that's a proposition that perhaps could always be advanced, but there's an assumption, as it were, that when Parliament does something, puts its mind to it, with the exception, which is referred to in the speech of Lord Hoffman, if I could just take you to that.
So it's volume 10, tab, you can catch the tab number.
10.107.
107.
Yeah. And I have it as page 131. This, in a sense, is like the high watermark of the way which Kate is put against it. I think the submission contains within it the seeds of its own destruction. What Lord Hoffman says at 131, adding, as he says, a few words about the importance of principle of legality in a constitution which, like ours, acknowledges the sovereignty of Parliament. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act of 1998 will not detract from this power. The constraints upon its exercise by Parliament are ultimately political, not legal. But then, the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general ambiguous words. This is because there is a too great a risk the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most base general words were intended to be subject to the basic rights of the individual, and then he equates the way in which the common law can march in step, if not in advance, of countries with the benefit of a written constitution. Now, we submit that it is one thing to say that when there are general words, as it were, in a provision without context, that principle can be engaged. But quite another when Parliament has clearly determined that there should be detention in certain circumstances, has chosen in certain conditions to make it mandatory that there be detention. In other words, it's vouched for directly. In others, in contradistinction, and no doubt as a matter of forethought, deemed forethought, have decided to give a discretion to the Secretary of State. To say they've overlooked here the presumption of liberty in the qualified way in which I respectfully submit it is to be described, in our respectful submission, is it's simply not tenable. And your lordships and my lady may recall one of the more vivid and perhaps unfortunate dismissive references to Magna Carta in one of the emails which Mr. Westgate read out with ill-concealed relish, was actually couched, if you remember the words, in a context where he juxtaposed Magna Carta with the provisions of the Act. So ignore the unlovely language. In essence, he was right. The Act itself validates the infringement of the right to liberty, and indeed, as was said by Lord Wright in the Livingston Anderson case, even Magna Carta recognises that. And in our submission, the provisions as to bail, which were also looked at in this context, lead to no separate conclusion. If one looks at page 43 of A1, that's just the same page which we were looking at, page 43 and indeed page 44. It's not page 4, forgive me. Where are the effect of, where's the bail? I'm going the wrong direction, I'm reminded.
43 is right, isn't it?
It is right, it is Schedule 2.
It's 43, top right-hand corner. Yeah, that's right, yes. I marked up my own page and then omitted to see it. It's actually quite instructive. Your Lordships may, and my lady may notice that this is dealing with restrictions on grant of bail pending appeal. And rather oddly, given the way in which my learned friends articulate the proposition, the way it's said, the tribunal shall not be obliged to release an appellant if it appears to the tribunal that certain A to E conditions are satisfied. It's actually curious that it doesn't say, though it must be its meaning, shall be obliged to release unless. But my point is not a simple...
Did you say that you accept that?
That's
because I don't
means.
think there's any reference here to propensity for absconding
Yes.
in the conditions. And it seems to me you start off with 29, which
Yes.
gives the right. It says, but, or that makes provision for bail.
Yes.
A decision may then be taken, and that's simply qualified by 30, but I have some difficulty in accepting that A, B, C, D, and E are the exclusive. It's the exclusive list of matters which might justify refusal of bail.
Yes, well, in any event, of course, my point was not so much to point out that linguistic curiosity as to note in 31 that an appellant shall not be released under paragraph 29 above without the consent of the Secretary of State, etc., etc. So what one sees there is he is given, as it were, an override. And again, in our submission, what that indicates is that the role of the Secretary of State in a context where the liberty of a person is in issue has been clearly calculated and calibrated by the legislature. So that's,
Is there any provision for bail pending the making of the order? I mean, there's a reference to it in 2.1.
Yes.
But it's rather odd that one has expressed statutory provisions governing bail pending appeal, where one can envisage the possibility of a considerable delay.
Yes. There are other provisions, as is there. Can I return to that later? I did at one stage have a very helpful note prepared in anticipation of this by my juniors. I'll come back to there are provisions for bail in that context.
Well, it's 22.
Yeah.
Paragraph 22 is applied.
And the other, one of the...
Paragraphs 22 to 25
yes, one of
are applied by paragraph 4A, 2.4A
yes.
of Schedule 3.
I'm very much obliged, my lady. One of the problems is that immigration law has now become segregated between various discrete acts. One isn't entirely sure always where one's going to find what. But I mean, the short answer, my Lord the President, and I'm grateful to my lady, the Baroness Hale, is that yes, there are relevant provisions. But altogether, the subject matter of these, and in particular the various paragraphs that are in issue in this case, is exactly the overcoming, rebutting the presumption in favour of liberty. And we say there's a carefully calculated scheme here let out which cannot be said to be redolent with the notion of parliamentary ignorance or avoidance of these fundamental issues. And in this context, we do say with respect that it is particularly striking that the Convention, which now, of course, informs, though it does not, as it were, necessarily extend as far as our domestic law, does not recognise any vice in a policy which presumes that designated deportees should be detained simply as a function of their status as such. It may be convenient, again, bearing in mind the hour and bearing in mind that my lord and my lady have seen this frequently, just to go back to the Court of Appeal's judgment, where two of the passages, relevant passages, are set out. And perhaps one will take it, both Chahal and Sadi are in our respectful submission to the same effect, but one may take Chahal because it was a deportation case. And what is there said, this is paragraph 61 at page 2195 of the Weekly Law Reports. Article 5.1 of F does not demand that the detention of a person against whom action is being taken with a view to deportation be reasonably considered necessary, for example, to prevent his committing an offence or fleeing. In this respect, Article 5.1F provides a different level of protection from Article 5.1C. And I would add parenthetically, since one's going to need to look at certain of the authorities relied upon my learned friends, Mr. Singh in particular, and Mr. Fordham in his printed case, one has got different levels of protection in these different subparagraphs, but as far as the one with which we're concerned is concerned, it says this: indeed, all that is required under this provision is that action is being taken with a view to deportation. And all that one has added to that in the Sadi case, which one sees cited immediately below, is that there's a temporal limitation. That's what, again, referred to, Sadi is used as a vehicle for referring to Chahal at paragraph 113. Any deprivation that is between D and E of liberty under 5.1F will be justified only for as long as deportation proceedings are in progress. If such proceedings are not prosecuted with diligence, the detention will cease to be submissible. So one has there expressly a temporal limitation. And that is all. Purpose and time. There is nothing in that that is antithetical to a presumption in favour of detention, and in our respectful submission, those authorities show that from the Convention perspective, that is all that is required. They exhaust what is required, and they give no scope for the intrusion of Mr. Singh's notion that, as it were, this is somehow antithetical to a presumption in favour of liberty. Now, my learned friend, so that was his first argument, and we simply say with respect, the Court of Appeal essentially were right to rely upon these authorities, because if one reads them, one sees the only limits which they apply to this particular power, and they are not limits which say thou shalt not have a presumption. His alternative point was that nonetheless this may be a circumstance in which the common law demands higher standards than the Convention. And our response to that is, well, see Sadi in the House of Lords, because in our submission, the House of Lords in that case were perfectly content with a policy that in fact presumed detention for persons who fell within a particular category. If we can go back to that, that's the authorities 119 and 120. We refer to this in our printed case at paragraph 5.52. Volume 11.
And the paragraph in your case was
5.52, page 28. And if I may, because it, as it were, shortens the need to explain further Sadi, I'll then take you to the salient paragraphs which support the proposition. What we say there is a system which expressly involved a presumption in favour of detention has been upheld as lawful by both the House of Lords and the European Court of Human Rights In Sardi, the lawfulness of the Secretary of State's Oakington policy was considered in relation to cases whose material facts all post-dated the 2nd of October 2000. Under this policy, all on-entry asylum claimants falling within defined criteria, usually by nationality, were normally detained at Oakington while their asylum claims were lodged and decided in an accelerated process. This involved a policy presumption of detention in all cases falling within the relevant criteria. The House of Lords dismissed the challenge, then looking prospectively, Sardi, the European Court of Human Rights, did the same. At holding there was no violation of Article 5.1, and we say in 5.53 no material distinction between the powers in paragraph 16 of Schedule 2 to the Act and those that are in issue in the present appeal. Both contain discretions to detain. If the arguments ventilated by my learned friends had any force in present context, they would have had force, which they did not in that context. And in our submission, again, it's not conceivable that their lordships were unfamiliar with Liversidge and Anderson and its sequel. Just to show your lordships and my lady where one finds the policy that is in fact set out, if one goes first to the judgment at first instance of Mr. Justice Collins, which is it's at tab 119, and one looks for this purpose at paragraphs 4 and 5. At paragraph 4, one has an example of, and I think Mr. Fordham indicated, of a policy that was declared through the vehicle of a parliamentary question, and it's there set out. And then its summary, as Mr. Justice Collins put it at paragraph 5 across the page, 362 of the Weekly Law Report, it's thus apparent a decision to detain at Oakington is not based on any considerations whether the applicant in question may abscond or otherwise fail to comply with the terms of temporary admission. Indeed, the overriding, or as Mr. Martin puts it, governing criteria is whether the claim appears capable of being decided quickly, and then, as it were, the ways in which lists are drawn up for persons eligible, if that is the appropriate word for Oakington detention. This went, as I say, to the House of Lords. Lord Slynn of Hadley gave the leading speech. That's at the next tab. And one really needs to see no more than 21, paragraph 21, page 3138 of the Weekly Law Reports, when he summarises elliptically the policy that was in place in relation to the Oakington Centre. There's now no doubt that the justification relied on for the claimants being sent to and held at Oakington was that these cases fell within the category of those capable of speedy decision. So there's a presumptive policy. Yes. Paragraph 21, my lord. Paragraph 21, page 3138. And then one sees, he then goes into, against that factual background, is this a violation either of Hardiel Singh or other principles informing the detention powers, or, and he deals and disposes of that between paragraphs 22 and 26, and then goes on to deal with the argument under the convention, and again he deals with that from paragraphs 27 through to paragraph 30, and in the end it is decided that neither of the arguments in fact succeeded. So there's an example where we respectfully submit, in contradistinction to Mr. Singh, that one sees here that the common law and the convention march hand in hand. It isn't the case of one having priority over the other. In this particular area with which they're concerned, same decision reached. And finally, just to, as it were, inform the jurisprudence further, we give at paragraph 5.4, and again I'm very conscious of the need not to exhaust time, an analogous reasoning in an Antipodean case, the New Zealand Court of Appeal, where what was involved was a discretion given to police officers to exercise a power of arrest, and instructions were given by the police commissioner. The statute was neutral, but there was a presumption that was in the policy which we there set out at 5.54, and it appears, although we concede the matter wasn't the subject of argument, that the New Zealand Court of Appeal, as we put it at 5.55, considered it unobjectionable that there should be a class of case in which arrest, which is the analogue or the precursor of detention, would be the normal course of events, that's to say, a presumption in favour of an arrest in that type or class of case. So we say that's the jurisprudence. We say that the presumptive power to detain a designated deportee is rational on any view in our submission. It's ancillary to the deportation power itself, and indeed ensures the efficacy of the deportation power. So what Mr. Hussain is eloquently, but we submit with respect, unavailingly seeking to do, is to turn a well-established common law rule respectful of the value of liberty, that a person who detains must establish that he, or indeed she, has power to detain, into a rule that a person who has power, and here indeed power under statute to detain, must start from the position that he or she will not, indeed cannot, exercise that power unless he has good reason to do so, rather than from a position that he will or can exercise that power as long as rationally, unless there's a good reason in the contrary direction. We say, with respect, none of the authorities that are relied upon support or illustrate the appellant's position at all. And it is indeed, in our submission, a somewhat odd proposition that a person, a statutory officer, who is expressly given power to detain, should start from the position that he's hobbled in some way in his exercise. It prompts the question, why was he then given a power in that form in the first place? Now, my learned friend appeared to accept, as we understand it, that a policy which said there is a presumption in favour of release of anyone liable to detention under the Act, but that such presumption will not apply to murderists, rapists, committers of mayhem, to use my Lord Simon Brown's example, would satisfy the principle of liberty, but a policy which said, on the other hand, that murderers and rapists are liable to detention under the Act and would ordinarily be detained, somehow would not satisfy the underlying principle. Our submission is that once, as it were, he opens that door, we become now down to an exercise in semantics and not an exposition of principle at all. And there's a further point. Hardiel Singh, admittedly a decision of some antiquity, but has resonated in the jurisprudence from the time it was first articulated until now, and referred to both in the Privy Council in Tanteilan and by the House of Lords in Melbourne, which is construed as intrinsic, those principles, intrinsic to the schedule of the Immigration Act, properly interpreted. It has two major features. The first is that the power can only be exercised for the purpose for which it was conferred, and the second, that the detention must be limited to the period necessary for that purpose. What neither it nor the cases that have built on it suggest that there's a third feature unavoidable, that's to say that the power must be informed by a presumption of release. And we say, with respect, that is also significant. Now, may I make it clear that in articulating the proposition that one is entitled, as a policymaker in this area, to have a policy for, in this case, ex-foreign national prisoners, which presumes detention, I am not to be taken as seeking to suggest that the burden of proof in any particular case shifts to the detainee. We respectfully submit that this is another fallacy or confusion that underlies the assault that's made on our position, and we deal with that at paragraph 5.19 and 5.20 of our printed case, pages 19 and 20. We describe the presumption. The Secretary of State's policy contained a presumption of detention in relation to certain cases, and its effect was that in the presence of certain factors, the outcome of the decision-making process would normally be that detention would follow. This type of presumption must be distinguished from other types of presumption which have been the subject of case law. Such cases often deal with a type of presumption which is a tool of legal proceedings. Such a presumption usually regulates the burden of proof in legal proceedings. Thus, a presumption that a deprivation of liberty is unlawful regulates the burden of proof in relation to that issue. The burden is on the custodian to show that there was a power to detain. None of that is in issue, but none of that, with respect, is relevant to the issue before the House. As we conclude, having analysed Liversidge and Anderson, this type of presumption, this is paragraph 5.28 at page 21, regulating the burden of proof in legal proceedings is different from the type of presumption that was contained in the Secretary of State's detention policy. Little assistance, indeed we would respectfully submit no assistance, can be gained from the existence of the former type of presumption when considering whether there are any legal inhibitions on the latter type of presumption. The fact that in legal proceedings the burden of proving a certain issue is allocated to one party rather than the other does not assist in deciding whether the Secretary of State may in principle lawfully give guidance when certain factors are present. The decision should normally be to detain. And then at 5.29 we refer to two cases relied on by the appellants, which in our respectful submission have the same vice in terms of their irrelevance as the authority brought to the table by my learned friend Mr. Singh this morning before the short adjournment, which I shall look at, if I may, in a moment.
You're saying it's not really a presumption, it's a starting point.
It's a starting point. It's a starting point, yes. But what I'm saying has nothing to do with who bears the burden of proof when one has a particular law. That's what both Bordikoff and Bykov were concerned with. And I think, with respect, Ilyakov, which my learned friend referred to this morning, Mr. Singh, really leads to the same conclusion. Can we just know, I want Ilyakov. 24, tab 124.
24, tab
210. 240. 240. 240. The Bulgarian case. This was again, one has to bear in mind, a 5.3 and 5.4 case, so again one bears in mind that there isn't in any event an exact read across in convention terms. The court's assessment starts at paragraph 76 at page 14 of the report. Paragraph 76 sets out the length of detention. The persistence of reasonable suspicion, this is 77, the person arrested committing offence is a condition sine qua non for the lawfulness of detention, but after a certain lapse of time it no longer suffices. In such cases, the court must establish whether other grounds given by the judicial authorities continue to justify the deprivation of liberty. And then they go on to certain procedural matters. And what then happened was that the European Court of Human Rights decided that the domestic courts had reached a finding that the detention was warranted on the basis there were no exceptional circumstances warranting release. That's at 82. Then they go on, and this I think I will need to read the next 6 paragraphs or 7 if I may. However, the fact finding was not based on analysis of all pertinent facts. The authorities regard the applicant's arguments he'd never been convicted, he had a family and stable way of life, after the passage of time any possible danger of collusion, absconding had receded as irrelevant. They did so because by virtue of Article 152 of the Code of Criminal Procedure and the Supreme Court's practice, the presumption under that provision was rebuttable only in very exceptional circumstances where even a hypothetical possibility of absconding, reoffending or collusion was excluded due to serious illness or other exceptional factors. Mr. Singh rightly says that's a matter of substantive law, and then matter of adjectival law. It was moreover incumbent on the detained person to prove the existence of such exceptional circumstances, failing which he was bound to remain in detention on remand throughout the proceedings. 84. The court reiterates that continued detention can be justified in a given case only if there are specific indications of a genuine requirement of public interest, which, notwithstanding the presumption of innocence, outweighs the rule of respect for individual liberty. So there's the Court of Human Rights recognizing that these are rebuttable presumptions. Then they refer to earlier authorities saying mandatory detention on remand per se is incompatible with Article 5.3. We haven't had time, obviously, to look at the jurisprudence supporting that, but one presumes that what was absent was the ability to bring a person before a judge, or maybe even the possibility of release at all. But be that as it may, we're not contending. First of all, we're not in the 5.3 area, but secondly, we're not seeking to subvert that obvious conclusion. Then something that attracted the immediate attention of my Lord Roger, where the law provides for a presumption in favour of factors relevant to the continued grounds of continued detention, the existence of concrete facts outweighing the rule of respect for individual liberty must nevertheless be convincingly demonstrated. So what they're there saying in our respectful submission is they acknowledge the possibility of a law, whether in primary law, in our respectful submission, in policy informing the exercise of powers under primary law, it is appropriate to have, or can be appropriate to have, a presumption. Nonetheless, one has to make certain that there's convincing demonstration of facts that justify the rule of respect for individual liberty. Then they go on to deal with the burden of proof, and they say shifting the burden of proof to detained persons in such matters is tantamount to overturning the rule of Article 5 of the Convention, a provision which makes detention exceptional departure from the right to liberty, and one that is only permissible in exhaustively enumerated and strictly defined cases, of which one, of course, is 5.1f, which they were not considering. And then they go on to say, even though facts over the page 16 that would have warranted his deprivation of liberty may have existed, not mentioned the court's decision, apparently owing to the operation of the presumption and the shift of burden of proof, and it is not the court's task to establish such facts, etc. It's for the national authorities to examine all the facts, etc. In the present case, this is the conclusory paragraph, the court finds that by failing to address concrete relevant facts and relying solely on the statutory presumption based on the gravity of the charges, and which shifted to the accused the burden of proving there was not even a hypothetical danger of absconding, reoffending or collusion, the authorities prolonged the applicant's detention on grounds which cannot be regarded sufficient. So our submission on this case is, first, it is dealing with Article 5.3 and not Article 5.1f, and one notes that the court is astute at 85 to remind one that there are or may be different considerations applying. Secondly, that in this particular case, there was not only a presumption in terms of the law, but there was a shift of the burden of proof, and it was those connected features that were found to impugn or undermine the validity of the detention. And thirdly, associated no doubt with that, was the fact that the court simply did not consider in detail the relevant facts. And we say with respect that when one is read with a measure of care, this simply provides no convention law support for the broad proposition that Mr. Singh relied upon it for, to suggest that a presumption in favour, or a starting point, to use my Lord Collins' phrase, in favour of detention is somehow invalid, certainly under Article 15F. Two more cases were referred to. The first was Rio, a decision of my Lord Simon Brown in particular, the Harrow Magistrates case. And in our respectful submission, again, this does not go the distance that Mr. Singh wishes it to travel. That's in 16 tab 155. And again, taking the matter as shortly as I may, the question that was posed was in relation to Section 25 of the domestic legislation in relation to bail, as to whether or not the impact, of Section 25 of legislation. This is at paragraph 15. Upon Section 25, defendant's right to bail in two particular circumstances, and both are said to arise in the context of Article 5.3. So again, with great respect, that's already a pointer away, not in disrespect, look, and Lord Brown, with great respect to Mr. Singh, that's a pointer away from saying there's any particular relevance to this case in this particular issue. Then one sees that what there had been was, as it were, a shift in the burden of proof between the unamended section and the amended section. The unamended section, my Lord, sets out at paragraph 22 at page 259, the amended section at paragraph 19 above. Then one sees at 27 Mr. Emerson, who is then appearing for the public authorities. I do not understand, my Lord said, Mr. Emerson, for the respondent and interveners, to argue the section should be properly construed and applied in such a way as to put the burden on the defendant to provide good and sufficient reason for bail. Certain to my mind, such an approach is irreconcilable with Strasbourg case law. Ilyakov is cited, and then my Lord refers to two key requirements in 5.3 again. Onus on the prosecution, good and sufficient public interest, reasons, and all relevant considerations to be taken into account. And in the end, my Lord found it possible to read the provision down in a way that was Strasbourg compatible, if I could use it in that formula. And my Lord, perhaps at paragraph 35, whether or not, because there was so little difference then between the parties in terms of construction, Section 25 needs to be read down to achieve the agreed result in a little moment. Like him, third sentence, I read the sections placing a burden on the Section 25. Defendant has to rebut a presumption. If he fails to do so, will be denied bail. And in the vast majority, the court won't have to worry about, as it were, who bears the burden. They'll look at all the facts and they'll come to the same conclusion on whomever the burden lies. But my Lord says there are occasional cases where burden is decisive and the default position is that bail would have to be granted. All with respect in the context of a different provision of the article, all with respect in the context of a shifting burden of proof, nothing germane to the issue of the validity of a particular policy in the exercise of a statutory discretion. And finally, SIM.
Well, the default position in our context is what?
Well, in a context where there are, because again one has to bear in mind certain hypotheses here that the policy was published, etc., etc. All I say is where, as it were, the law, in concluding be informed by particular policy, makes certain provision, then it remains for us to satisfy a court, if a court sees the matter, that those criteria are satisfied and not vice versa. I mean, that's the burden of proof issue. But it doesn't mean that we can't start off with having a policy of presumption. Whatever it, yeah, whatever it is we need to prove, but the issue before the House, before the court at the moment is what are we entitled to put into what I call, as it were, the substantive provision. That's really it. Can I just say with respect, I mean, Sim again, I'll just give you the reference, volume 4 at page 417. That was an Article 5.4 case. And again, I'm very conscious of the time, and there are certain matters that have to be... I mean, if one reads, we respectfully submit the relevant paragraphs one needs to read, the head note just to understand what the case was about, paragraphs 5, 6, 8, 10, 37, 44, and 49. And we say effectively, again, it comes down to a burden of proof case. So that's what we say with respect in relation to our first proposition, namely it is a carefully contrived scheme by the legislature, bearing in mind the fact that they need to justify the detention. They provided for it both in primary legislation, which itself stipulates for detention in certain circumstances. They provided for it by giving the Secretary of State carefully calibrated powers either to detain or release or to consent to bear matters of that kind. Nothing inconsistent with the common law legislation, nothing inconsistent with Strasbourg law, nothing inconsistent with Antipodean law insofar as it's considered this particular issue. And in our respectful submission, accordingly, the Secretary of State should succeed in relation to what is effectively now a challenge to the September 2008 policy onwards, that small window between the time when the presumption was for detention and the revision of the policy a few months later when it reverted to a presumption and release, equally within, of course, the discretion of the Secretary of State. If I may then go to paragraph 2.
Just before you do.
Yes, of course.
What is the effect of that presumption on an application for bail? Does it, as it were, displace principles that might otherwise be applicable where somebody applies for bail? I mean, it's a quite different situation from a situation where you have somebody who's charged with a criminal offence and is detained pending trial.
Yes. Well, in those situations, the present view, I think, of the court or the House of Lords was that it is for those who wish to, as it were, deny bail to establish the facts. The burden of proof lies upon them.
Yes, as far as burden of proof is concerned.
Yes.
But as far as the presumption is concerned, you would say, I think, there's a presumption against grant of bail in these cases.
Well, yes. I mean, that's a question of how one reads the statute. I mean, it could be that it's entirely neutral. I mean, I'll come back if your Lordship particularly interested in the question of bail. But as I say, I mean, there are two different issues. One is the content of the substantive law, and the two is assuming the law is to such and such effect, who bears the burden of proving what?
We're not here concerned with the immigration judges and people who deal with bail, are we? I mean,
we're not concerned.
Well, are we? I mean, they're not in this challenge, are they?
No.
We don't know what their approach is. We have the first idea what their approach is.
Ask me a question. But I mean, if there needs to be an answer, I'll try and provide it after the adjournment on that particular issue. No, we're not.
And we don't know what they, for all one knows, the immigration judges, one says there's a presumption of not granting, the other says there is. I've no idea what they say.
No. Well, as my Lord says, it's not an issue in this case. I have no idea about how they approach it. There's some quite interesting decisions in relation to both these two persons when they applied for bail, and strong views expressed by the immigration judges about the validity of the application, which was denied on several occasions. That's for something for later.
Is it rather a narrow dividing line? And I completely understand the distinction between a substantive rule, whether it's in the statute or in a policy, saying we will detain unless, or we won't detain unless, or we will only detain if, whatever. And a burden of proof. Because if you take, for example, the example that Mr. Singh raised of the Mental Health Act detention, You could say that the substantive law was, once you're in a mental hospital, you can be detained indefinitely, basically, unless you're safe, unless you're sane or safe. And you could say that was the substantive rule. It entailed, of course, a burden of proof on the person to show that he was sane or safe, but you could say that that was a substantive rule. So you could, of course, turn it the other way round. Now, how does your distinction operate in something like that? I mean, I find it quite hard to get a handle on.
I see the point my lady is making. In that particular situation, one has, as you say, the substantive law says, let's assume that you're going to be detained unless you can show that you are unless you are not safe, as it were. Then the burden of proof comes in as to, right, that's a substantive law, you're going to be detained unless you're not safe. Who then bears the burden? And then the burden would be, according to the jurisprudence now, it'd be the burden of those who wish to maintain the detention.
That's
yes, and
that was a result of the declaration of incompatibility.
That's right.
But I think the point I'm only trying to
no, I understand
put to
what
is
you're
this
saying.
difficulty of drawing a distinction.
It's
pretty elusive.
It can be elusive. Yes. But nonetheless, I mean, it can be elusive. But as we're going to, when we come to the anismic issue, certain things are elusive, and sometimes boundaries are very difficult to define in law, but the boundaries nonetheless exist. And there are two categories here, one substantive, one question of burden of proof in our respectful submission is established. I'll think, if I may, a little bit more about whether I can provide a more coherent answer to my lady after the adjournment.
Well, there is, of course, an easy Article 5 answer, but I'd like to put that to one side.
Yes, I understand.
The Article 5 answer is you're not allowed to detain somebody unless they're reliably shown to be of unsound mind. But one wants to stand back and
see it more as a matter of general principle. Yes, I understand. If I'm right about my first proposition, in our respectful submission, that if, as it were, convention law does permit a presumption in favour of detention simply on the basis of being a designated deportee, as long as time has not been too elongated, it would certainly endorse one where there are additional and rational reasons against release. I don't want to preempt what I'm going to say after the adjournment in response to the WL specific cases, but what we say, and with great respect, I think we say with some force, notwithstanding Mr. Hussein's demur, at paragraph 5.16, we deal generally with the virtues of policy, and then we go on to deal with effectively our proposition 2, in the absence of the legal constraints purportedly found by Mr. Justice Davis, but denied as there exists validity by the Court of Appeal, it would therefore be unsurprising for a detention policy to include guidance that if certain specified factors are present among the circumstances of an individual's case, detention would normally follow, unless a contrary decision was appropriate in that specific case because of the individual circumstance of the case. For example, it might be unsurprising to find a provision that those subject to deportation action who've previously been convicted of Bail Act offences, who had a record of absconding from bail or immigration controls, are normally to remain detained pending deportation. Absent those legal constraints, such a provision would be entirely unobjectionable. Indeed, it might be thought surprising if in those circumstances the policy was nevertheless legally required to provide the individual should normally remain entitled to liberty. Now, Mr. Hussein, when taxed with the force of that paragraph, simply said he didn't accept it. In all circumstances, one had to start with the presumption in favour of release, even if one then carved out massive portions of it by saying that in certain circumstances, those relating to serious offenders and the like, one would be able to override the presumption in favour of release. Again, we respectfully submit that that becomes, in the end, an issue of semantics, and we respectfully adhere to the fact that in the absence of some contrary constraint, the conclusions that we reach there are wholly reasonable. And that's really all I need to say about Proposition 2, which is very much a footnote to Proposition 1. Now, Proposition 3a I can deal with equal swiftness. It was found as a fact that between November 2007 and September 2008, there was a blanket policy of detention of all foreign national ex-prisoners who'd been sentenced for offences listed in Cullen 1. The Court of Appeal found that, paragraph 45 and 48, subparagraph 1. They did so basing themselves on material which had been produced by the department since the hearing before Mr. Justice David, who'd made a finding that during that period there was a presumption only against release, but one capable of being departed from exceptionally in individual cases. And we certainly don't seek to have the finding made by the Court of Appeal reviewed by this court. The question as to whether or not in the preceding period there was or was not a blanket policy has been to some extent debated, but whether or not at the end of the day it makes significant difference in terms of the question of principle, we respectfully doubt, because of course we have the publication problem in respect of both periods. But on the assumption there was a blanket policy, as we say, only because we don't want to concede, obviously, that the Court of Appeal were in error, we say they actually made a solidly based finding that should not be reviewed about the extent, in time terms, of the blanket policy, that there was clearly a public law flaw. It is well established, of course, that the adoption of policy is at the heart of rational decision-making, but it is equally well established law that a decision-maker, in applying that policy, must be open to representations as to why it should not be applied to the representor. And so that, in our respectful submission, is common ground between the two parties, the contesting parties. Now, our second proposition in paragraph 3 and our proposition in paragraph 4 to some extent overlap and indicate, I hope, that the dividing line between the parties is somewhat narrower than Mr. Hussain considered, although we entirely accept that he was entitled to take the view that in seeking in our printed case to explain and to extent justify the finding of the Court of Appeal, we went beyond that which, at any rate, I am presently minded to go. What we do agree then, just to define the limits of, as it were, the concession, that a policy must not, if unpublished, adversely affect any contradicted published policy. Honestly, one that was more benign would hardly be the subject of complaint. Which
Mr. Benefit, it wouldn't be the subject of complaint by the people affected by it, but the public might.
Well, the
public might very well find it very surprising if there were a published strict policy, but behind the scenes, the Home Secretary were adopting a more liberal policy, shall we say.
The public would be entitled to be surprised, but whether that would give rise to some legal right...
Well, why not? Why should it not be judicially reviewable? Challenge. It was equally, it's equally deceptive.
Yes. My Lord,
it's not going to rise in this case, but
no.
It's just, I put down a sort of marker on adversely.
I hope I'm betraying, not as it were, waiving privilege when I say that I only wrote in adversely at a late stage, having originally adopted a more out-and-out one, but for present purposes, adversely in relation to this case. So let's assume that adversely comes in because I'm concerned with this particular case and perhaps park the issue for debate at some later stage, if it ever occurs that a more benign policy is concealed within the vaults of the department. Oh, happy day.
Actually doing
Does it? It does happen. Well, my Lord Roger knows far more than I about the internal workings of public administration.
Sorry, could you dictate the concession which I
Yes.
understand you're making as against your printed case?
My position is in 3.2, which I've just read, and in 3.4, in 4, which I think is one that those who read the printed case might have said is not entirely consistent with it. Because what we say is such a policy must itself be published and inform discretionary decisions in respect of which the potential object of those decisions has a right to make representations. Now, the point is, of course, that the Secretary of State would in fact wish to publish those policies. There were indeed published policies throughout the period with which the Supreme Court is concerned. The vice, alas, was that from April 2006 until September 2008, there was a lack of symmetry between the published policy and, on the other hand, oh, my Lord, that's
It's a lovely phrase.
It's an accurate, but one might rephrase it in different ways. But anyhow, the fact was they weren't the same. Let's put it in that more vernacular way. But the point is that there was this lack of symmetry, lack of sameness between the published policy in the blanket period and indeed the practice between April 2006 and November 2007 until, of course, September 2008. Before Mr. Justice Davis, I just remind the court of why it is that I'm in a position to, as it were, retreat, reculer pour mieux sauter, on other issues it may be. But before Mr. Justice Davis, the Secretary of State accepted a public law duty to publish such policies, but he argued in effect that the political statements made and widely publicised by successive Secretaries of State constituted sufficient publication. That was rejected at first instance. In point of fact, it was not appealed, and it was the Court of Appeal who independently determined, in effect, that the vice was the lack of symmetry and not the non-publication per se. And on the facts of the cases before them, one can see that that conclusion was not unreasonable, because if unpublished policies do not contradict but merely amplify published policies, then their non-publication should not be a cause of concern, let alone unlawful in public law terms. Now, in our printed case, you will have noted that between paragraphs 4.8 and 4.23, we enter into a lengthy disquisition about the differences between policy on the one hand and law on the other. And the general points we make, we have no reason to retreat from. But what we do accept in our fourth proposition now, that the convention jurisprudence, and we would respectfully submit on the whole, the common law would appear to be to the effect that if one is going to take decisions, in particular decisions that affect rights or interests as vital as liberty, in the exercise of discretion, one ought to publish the criteria which inform those decisions in order, in effect, to allow those who are their object to make representations against them. It seemed to us upon reflection that that's what at any rate the common law required. And although, as I say, some of the cases cited in the convention jurisprudence might be thought not to go quite so far as we put it at paragraphs 420 through to 422, one can see an argument for saying that as far as the convention requirements of prescribed by law and transparency are concerned, that Hardeal Singh, coupled with the Act, might arguably satisfy that those principles. We're not seeking to pursue that. It's quite not uninteresting. Again, I'm conscious of the time, and I don't want to deal with matters that are not controversial. The case that was cited by BID as the high watermark of an obligation to be transparent in terms of policy and the like, the Kauder case, which is at tab 239, a Polish case, and it's cited by Mr. Fordham in paragraph 17 of his printed case. If one actually looks at it and sees what the concerns of the European Court of Human Rights were in that case, the principle was set out in 49, which my learned friend cited, but then one looks at paragraph 50 and 51, one sees how far short the Polish authorities were falling of the obligations. One sees, well, it's actually an exact read across. But that, as I say, we accept the propositions in 4, and what we're more concerned about, and this is of some importance, we're more concerned with what I would call the practical considerations of how far this obligation to publish may go. And the practical considerations would, I respectfully submit, be likely to be shared by all departments of state and indeed many other public authorities. The first limit that we wish to establish is that the Supreme Court does not rule that every internal guidance on administrative detail, including, because this has been the subject of argument, at what particular level within the department and by what particular processes decisions should be taken. Secondly, we don't want it suggested that while we are in the process of evolving policy, changing from one policy to another, that we are not obliged to publish drafts of proposed policies still in the state of evolution. And thirdly, we are concerned that respect should be paid to the fact that by reference to certain issues, for example, issues concerned with national security, those could properly remain unpublished. And we do see...
The last has been conceded, I think.
Yes, well, yes, well, there we are. But I was setting out our stall because we want to be careful with respect not to invite the court to go further than we're prepared to concede. And can I just show the court again Gillen, which Mr. Fordham helpfully read, because we say the key to Gillen, and it's the up-to-date jurisprudence, Strasbourg post-House of Lords, going further than the House of Lords, really lies in the last sentence. No, it's the European Court. It's tab 414 of, I think, Battle 41.
What bundle? 41.
41. And this was a... I'm looking for paragraph 77, which is at page 1148. Now, Mr. Fordham used this to illustrate his general proposition that there is a convention obligation to protect against arbitrary interferences by public authorities with rights safeguarded by the convention, which we would respectfully submit was no doubt mirrored in common law. But it's the last sentence which was given less emphasis, but we respectfully submit should be given equal weight to that which goes before it. The level of precision required of domestic legislation, and for present purposes we include within that policy guidance of the kind that Mr. Fordham had in mind, which cannot in any case provide for every eventuality, depends to a considerable degree on the content of the instrument in question, the field it is designed to cover, and the number and status of those to whom it is addressed. And we respectfully submit that accordingly, the Strasbourg jurisprudence is not an open sesame, compelling member states, public authorities, to publish each and every document that could be described as policy guidance or the like. It is, as is always the case, a very fact-sensitive issue. And in articulating your Lordship's and my Lady's judgment, we would ask you to bear that particular sentence in mind.
Well, at least in this case, we're not dealing with the frequency of reviews or by whom these reviews are to be carried out. It's a much more fundamental conflict between the two policies.
No, that's certainly so. But one can quite see, I mean, it has been, questions were raised. My Lord Roger raised the question, what happens if the person who is actually under what we call the internal policy, group 2 person, sick, is it to be said that because it's then taken Vice, the group 2 person, by group 3 person, it's going to be... It's that kind of, as it were, administrative detail. We say, yes, you need to know what it is you need to aim at. If you're going to be detained on the basis that you are a threat to public order, you need to be told that that's a criterion that informs the decision-making process, so you can address it. Matters of that kind.
It's the substance, isn't it? It's the substance rather than the mechanics.
It's substance rather than your Lordship.
Rather than the process.
Well. Yes, I would so submit. So what we submit really is this. If the court were prepared to endorse our propositions 3.2 and 3 and 4, we say they would acceptably define the limit as well as the reach of the obligation to publish. So, my Lord and my Lady, I now come to...
Can I just be quite sure that I understand the way these two fit together? It's slightly awkward because one has to turn the page. When you say such a policy,
yes,
is that
a policy which would be a source of legitimate expectation for those to whom it's applied and the relevant considerations?
So it's really a 3-2 policy.
Really. It's a 3-2 policy, yes. Such refers back. I know.
Yeah.
Now, I could deal, if I may, with the fifth proposition within 2 minutes, if that's convenient to the court. It's basically a question of fact. And I just simply remind the court of the facts which are now established, that from April 2006 to November 2007, there was at any rate an unpublished practice which included a presumption in favour of detention if it was somewhat unevenly applied. See the Court of Appeal at paragraph 45.1. From November 2007 to September 2008, there was a blanket policy, one to which no exceptions would be considered in operation for all foreign national prisoners convicted of serious crimes, respect to whom decision to deport be made, they should be detained pending deportation, same paragraph. That blanket policy, third point, was unpublished. And fourthly, that policy, and we would concede a substantial part of the uneven practice from April 2006 to November 2007, was inconsistent with concurrent published policy that there should be a presumption in favour of the release of prisoners of that category, to be overborne only on the fact of individual cases taking account of the risk of absconding or reoffending. And we say these various factors amounted clearly to a violation of the principles set out in our third paragraph. So that's by way of concession. My Lords, if that's, and my Lady, if that's a convenient moment.
Yes, it is. Thank you.